Good morning, everyone. Thank you for joining us. My name is Sandeep Gokhale, and I'm here with my colleague today, Mike Sharon. We have more than 1,500 people registered for today's webinar, which goes to show the significance of our current topic today, which is current trends in unionization and collective bargaining. Now, the format for this morning is as follows. We'll present from 9 to about roughly 10 a.m., and then we'll answer questions till about 10:30 a.m. If you have a question for us, please type it in the Q&A box on your screen and not in the chat box, which should be disabled. We'll do our absolute best to answer as many questions as we can. And if we don't get to your question, please reach out to us after the presentation and we'll absolutely get back to you. Finally, a recording of this presentation and the slide deck will be on our website within a day or two. So with that said, let's get started.
Hi, Sandeep, it's Catherine. I'm Catherine Ford, everyone. I'm a colleague of Mike and Sandeep's, and I'm going to be moderating our discussion today. So as Sandeep mentioned, we're going to be talking about current trends in unionization and in collective bargaining, and we're going to cover it in primarily three different areas. The first is that we're going to talk about what we're seeing from a bargaining perspective and unionization from over the past year and what we see coming down the pipe. We're then going to focus a little bit on a topic that's been in the news, particularly in Ontario in the last couple of weeks, and that's wage restraint legislation and some of the case law in this area. Finally, we're going to move to a discussion of practical tips for the bargaining table. So with that, we're going to get right into it and start on our first topic, bargaining and unionization trends. And with that, I'm going to start with a question for Mike, and that is that it seems like across industries, wages are on the rise. How have the current economic conditions impacted the bargaining table?
Hey, good morning, everyone. Thank you, Catherine. I think this area, just to start out, has to be one of my favorite areas. Multiple moving parts, multiple personalities, and many, many factors. And we're going to try to go through some of those factors today that affect the various outcomes. And I'd ask everybody to think about this for a moment. Can you actually remember what we were doing in collective bargaining or any of these trends back in the fall of 2019 pre-COVID, almost like a time I've forgotten about? Can you remember the economic crash of 2008? Can you go back even farther and remember the economic crash in 1989, 1990 and how it affected our respective parents? How many of us have parents who remind us today that when they first took their first mortgage out and the first home they bought, they were actually paying 18% interest rates? We're going to try to move forward, obviously, from 1989 to where we are today. And we're going to talk a little bit about consumer price index, the cost of living. You will have heard them acronyms, CPI and COLA, and how they're also relevant to collective agreement negotiations. As you know, CPI represents changes in prices as experienced by Canadian consumers. It measures the price change by comparing through time the cost of a fixed basket of goods and services. So it talks about whether or not our dollar that we've earned is actually still purchasing the same amount of goods and services. They divide that up into 8 major components. They talk about food, shelter, households, clothing, transportation, healthcare, recreation and education, even alcoholic beverages, tobacco products, and even recreational cannabis. Let's talk just about food for a moment. 1995, how much was the cost of a loaf of bread? It was $1.29. We fast forward to where we are today, it's likely costing each of us $3. Milk back in 2015, $4.93. Today, $5.90. A dozen eggs, $1.63 in 1995. 2010, it had jumped to $2.61. This year, it's actually up around $3.87. What else impacts negotiations? We think the availability of workers in sufficient numbers with sufficient skills. I read an article over the weekend connected to the term ghosting, and I had heard ghosting, but not in this context. This was all about employers and employees, as opposed to what people talk about when they're ghosted when you send an email to somebody. This article said the employer's experience had been 80% of those who apply for a job are unreachable. And then even worse, of the 20 who agree to be interviewed, only 3 show up. So it really does depend on your sector, though. If you were in the hotel industry, you suffered through COVID, and now many of you aren't opening all your hotel rooms because we don't have enough sufficient house persons available to clean the rooms. Shortages in the health profession that we're all aware about. Move over to a skilled trade, and we hear lots about shortages in skilled trades, but if you talk to the electricians, they would say there is no such shortage. The phrase that seems to keep coming to mind as we get ready for some of these description of some of these trends is, and I think it's a phrase I hear from everybody, where did everybody go? In this ever-changing context, we want to provide you with information and evidence to prepare you either for your next round of bargaining or your next round of compensation where you're hoping to stay potentially in a non-represented fashion, non-union, and you want to make sure that you're paying competitively. We know that each of you want to retain and engage talented workers that you lead. We know that we want compensation to be a neutral factor. We want people to think that way, that comp is neutral when they're thinking about coming to join us, when they're hoping, we hope they stay with us, and or if they're considering leaving, we hope they think of how we pay people. The overall compensation basket is actually competitive. We seek out best practices. You try to assess what your competition is doing. We consider our margins. We're trying to protect those margins. Where it's possible, we might even put through a price increase. Where it's not, we these days might even experience single-digit incursions into your margins. We wish it was that simple. We all know it's not. Who should be paid what and why? Has COVID impacted different parts of your population and your workforce differently? But at the end of the day, we know that everybody that's with us today, we harbor that universal desire to make sure that we are fair but prudent in the spending of money. I would think maybe, Catherine, we move over to slide 4 and we actually look at some of the recent trends. And if we look at this first slide, this is a trend on inflation, something that's been in the news a fair bit recently. You'll see that back in only a year ago, we're looking at 4.7% in inflation. But then we look into this summer and we all read the news about it where inflation spiked up to 8.1%. Really significant and really causing pressure with respect to both collective bargaining and frankly, the ability to stay union free, given that promise from unions that they could cause your employer or persuade your employer through negotiations to potentially have higher compensation. You'll notice that this slide, it takes us down to 6.9%. That trend is down, but we don't think it's going to markedly decrease anytime soon. We know that, for example, even today sometime, the Bank of Canada will, as we suspect, have another interest rate announcement. This year to date, there have been 6 interest rate increases, including a record-breaking 100 basis point increase in July, the largest rate hike since 1989. If we move over now to the jobless rate, so where have all the people gone? We see that most recent number down at 5.2%. Not that low since, frankly, pre-COVID. Significant pressure as a result of that with respect to a bargaining table or simply your compensation rates. Many of us have experienced significant jumps this past year. If we move over to slide 6, we see some national statistics. And I say that on purpose when I say national statistics, because depending upon where your operation is, if you were a CN or an Air Canada or a trucking company or a business that has properties across the country, you might be looking at these national increases. You'll see that 2017 to 2019 down at 2.6. Look how it starts to jump as we move into 20, slides a little bit in 21, but look at this current climate nationally, 5.6%, significant. And remember, that statistic is a year over year using October 22 over October 21. If we move to the next slide, and this is our pitch to you, is to remember national versus Ontario maybe, or even a jurisdiction. So we really want to make sure that you're looking at the statistics that are going to be relevant to your operation and what your employees may be thinking about. So national employer, you go back to that first slide. Ontario employer, and note here, please, these are all private sector agreements. We know that, for example, and we're going to talk about Bill 124, Catherine and Sandeep mentioned earlier, Bill 124 has put a restriction on rates of increase per year in the public sector. Will be more detailed shortly, but that caused the public sector to have an average rate of increase at approximately 1.3, 1.4%. Things skew these sometimes, and you as an employer, you want to take a look and say, okay, I'm looking at, Mike says in 2022, the average increase is 3.9%. My employees are going to be looking for 3.94%. Is that really an accurate number for who I compare with? So we know that you can drill down and get information in manufacturing and healthcare, and we can help you get those numbers. We can show you where to source them, or we can source them for you really quickly. And we encourage you to do that if you're getting ready for bargaining or you're getting ready for your annual comp review. In the private sector, remember that the construction companies all bargain once every 3 years. 2022 was a year they bargained, and they saw double-digit increases. So did they possibly skew upwards the private sector settlements? Did the public sector 124 possibly skew down the public sector settlements? And so those are things to think about. I think at this point, I want to turn it over to my colleague Sandeep, who's going to take you through some of the actual trends that he has been seeing as well.
Yeah, I think it's super helpful for Mike to walk us through those wage numbers, because I think there's a difference in perception and reality. If we were only to rely on the headlines and the news clippings, I think most of us would think that unions are negotiating collective agreements with wage increases that far exceed 3.9%. However, I think it's important to understand that the negotiated increases we're seeing, even using the 3.9% number, in my view, aren't truly reflective of hard negotiating by unions or as a result of kind of long strikes. In my experience over the last 12 to 16 months, and I think it mirrors many of my colleagues, it's employers who have come to the table with internal mandates to increase rates simply from a talent retention and recruitment strategy. And if you drill down into the specific sectors, I think if you look at private healthcare, so I'm talking about retirement home industries, manufacturing, food distribution, where there continues to be a significant shortage of labor, employers are looking to make swift changes to wage grids simply to remain competitive. So if you're in negotiations now and you're facing trade unions who are sitting across the table, leveraging kind of rich collective agreements as a negotiating tactic, I think it's also important to critically look at where some of this significant increases are taking place. Because I think if you do a deep dive, you'll see a disproportionate amount of increases that are being put at the front end of collective agreements and significant increases to start rates simply to address the recruitment piece. I think a lot of that has to ultimately do with the increases in minimum wage as well. So there's been a compression between minimum wage and a lot of start rates in collective agreements. And so employers, even on their own, have sought to try and increase those start rates just simply from a recruitment perspective. So I think you need to critically look at a lot of these numbers that we will be discussing today to start to think about, what they actually mean for you as your business, especially if you're in a sector or industry that perhaps, isn't facing a labor shortage or isn't ultimately, in the same position as, retirement homes, manufacturing, food distribution, just from a straight labor perspective.
Thanks, Sandeep. And I kind of want to build off that a bit, Mike. You mentioned in your initial comments, talking a little bit about COLA. And I think we're probably hearing more about COLA now than we have in recent years. Certainly, I think some unions look to COLA as a way to, hedge against that inflationary risk. Can you talk to us about, should employers be looking at COLA clauses to make wages more competitive?
I think, Catherine, I'd start by saying that our advice would be stay away from COLA when you can. Unfortunately, COLA sometimes can be a hidden increase. So you negotiate in a formula to figure out how a wage might adjust as it relates to CPI. The danger is that you're not actually costing that number when you look at what your actual increase is this year, but it's going to have a future impact, or at least a potential future impact. The other challenge I would say for most employers is when we walk away from the table, one of our jobs is to ensure that we have clear mutual expectations. I want the other side to trust what we've agreed with. I want them to trust us. I want to trust them. It means the language has to be crystal clear. And frankly, COLA clauses can be complex, and they have a variety of triggers. And I'll give you some examples. Let's assume you've got a union who actually has enough leverage that they can persuade you to actually negotiate COLA. Then if you're going to do that, what we've tried to do on this slide is to give you some best practices to think about, things that are important if you're going to negotiate a COLA clause. So first, the formula where the wage adjustment is less than a change in CPI, excuse me. So it's not one-to-one. When CPI jumps by a point, so does the wage increase. You want to have a different formula than that. You also want to try to cap the potential wage adjustment as well. So COLA formulas that are uncapped can lead to fairly extraordinary outcomes. The other thing is we only want to have a large increase. We want to have a large increase in CPI before it triggers COLA, so you can put higher thresholds in it. Where you see that float arrangement, what we mean by that is many COLA clauses say if COLA is triggered, the amount of increase in the hourly rate is folded into the hourly rate. A better clause, we believe, is have it that you identify what that rate increase is and simply pay out a lump sum. Many people refer to that as a float. And the final one, I think, is longer intervals for adjustments. So it's something to think about. Some COLA clauses say we're going to make an adjustment every quarter, whereas we would say try to make it annual in terms of frequency. We say that's one, from a cost perspective, but two, your payroll and benefits people won't appreciate you changing the hourly rate potentially in the middle of a payroll period 4 times in a year. That's another thing we do in collective bargaining, just to note it, a little off topic, but when you're negotiating your increases at a collective bargaining table and they say, for example, we're going to increase wage rates by 3% effective January 1, think about a clause that says we will increase those rates on the first full pay period after January 1. Again, it's tiny economically speaking, but it's of high benefit to simply the payroll administration. With that, I think we're going to pass it back over to Sandeep to talk to what are the other alternatives to COLA? Are there other ways to deal with this simply than having something that looks at that 8.1% inflation target?
Yeah, thanks, Mike. Most of us understand the issue of compounding in collective agreements. What we negotiate in year 1 of a collective agreement can impact costs in years 2 and 3. As such, on one hand, unions are trying to negotiate high percentage increases in year 1 of a collective agreement because unions and their members will reap the benefits of that in years 2 and 3, while the increases in years 2 and 3 build on what was ultimately agreed to in year 1. While employers are trying to effectively use lump sum payments to avoid compounding. In my view, it's smart to use lump sum payments to specifically address the inflation issue, because hopefully this is a blip over the course of a 10 to 15 year time frame. As such, you want to try and avoid significant percentage increases to address inflation because it's a now issue and it may not be a 2024 issue, it may not be a 2025 issue. So you want to try and avoid having those large percentage increases at the front end of a collective agreement because it can exponentially impact your costs as you move into years 2, 3, 4, and 5 potentially. Now, I will note that those employers who are successful in negotiating lump sum payments to complement percentage increases, we're no longer seeing those $150 lump sum payments that perhaps we saw in years past. We're seeing lump sum payments equivalent to percentage increases. For example, if you're a warehouse employer and you pay, your average rate for paying an employee is $22 an hour, that's ballpark $45,000 a year. A 1% lump sum, a lump sum payment equivalent to 1% is ballpark $450. So we're seeing those types of lump sum payments to actually address the issue of inflation, as opposed to perhaps the numbers we saw in years past. So, if you're starting to consider the use of lump sum payments and negotiating them in collective agreements, just be prepared that those numbers are going to be lower than perhaps what you may have negotiated as signing bonuses in previous years. The second thing I want to address is traditionally when we've negotiated collective agreements, we've seen one annual increase in wages. However, over the last couple of years, employers have had recent success negotiating increases in 6-month increments. And what this does is it helps an employer reach a desired rate for the purposes of recruitment and retention without having to pay for it all at once. For example, let's say we're an employer that, we've historically provided employees with 3% increases in collective agreements. But this year we want to do more. Instead of providing one 3% increase, an employer could simply provide a 2% increase every 6 months. This way, by the end of a 3-year collective agreement, you would have moved the rate 12%, but we wouldn't have actually had to pay the full 12% because we're only paying on the last 6 months of every year. So you get relief in the first 6 months of every year of the collective agreement. As such, while your rates would have increased by 4%, the true cost to the employer would have actually been closer to 3%. And that's an effective way to ultimately save money, but move your rates at a higher clip. Now, just be prepared that in a headlines or a press release released by a union, if you were to do something like that, a union will sell it as a 12% increase over the course of the collective agreement, but we know that the cost to us as the employer isn't actually 12%. Third, the other thing to remember is that unions, and most importantly employees, sometimes forget why certain rates were historically agreed to, and as such simply use the previous negotiated increases as a floor for future rounds of bargaining. Here's where employers really have to try and protect themselves as they get into these rounds of bargaining. So let's say, for example, we're an employer, we have an internal mandate to increase rates by 5%, or we otherwise agree to a 5% increase in year 1 of a collective agreement. What we're starting to do and support employers is to really identify in the collective agreement that 3% is what our annual increases are. However, in light of extenuating circumstances relating to COLA or the pandemic, something that we can hang our hat on to demonstrate objectively why we've increased more than what we historically have, we would then add an extra 2% in light of that and put language and codify that language so that in the next rounds of bargaining, it's in black and white in terms of why ultimately there was a significant increase in one of the years of a collective agreement, so that we're not stuck with a kind of a union trying to rely on pattern bargaining. And so that's where I think employers have to be strategic. And it's one thing to agree to, a 5% number, but start to think about the next 3 years when you're back at the table and how what you do here can impact what happens in the future. And the last thing I want to talk about is wage reopeners. So that's a concept where, let's say we agreed to a 3-year collective agreement, but we don't know what 2023 is going to look like. We don't know what 2024 is going to look like. So we agree on a wage increase for 2022, our current year, and we come back to the table in years 2 and 3 to negotiate an increase. There's pros and cons to that. Obviously, it leaves a lot of uncertainty, and I think part of the value of a collective agreement is creating cost certainty for a 3-year period of time, but ultimately understand that that is an option for some employers. And I think in limited circumstances, it can work, but be careful with it because you may not get the best bang for your buck with these wage reopeners because if things change, COLA stays the same or increases, we may be in a position where you could have sought value for years 2 and 3, and you missed that opportunity. So just be cognizant, be aware of that if you are an employer who's contemplating wage reopeners, because you can't really forecast what future years are going to look like.
Sandeep, one of the things you mentioned when you were talking about kind of separate types of increases was that concept of whether maybe there's a pandemic increase or things like that. Speaking of the pandemic, have we seen unions pushing for kind of COVID-related clauses, whether that's something related to additional sick leave, remote work, things like that? What are we seeing?
Yeah, I think in the early days of COVID, I think we can say that now, we saw unions proposing a lot of different language around pandemic-related leaves, boost to sick time. However, in my experience over the last kind of 6 to 10 months, that's dwindled. I think in large part because we now have legislation around leaves that's been codified in the ESA. And more importantly, I think priorities have changed for employees. We're now seeing unions focus squarely on wages to really address this issue of inflation. So I think a lot of it has to do with just the priorities changing for unions members as they get to negotiations. However, we did see some unions try and attempt to have temporary measures put in place by employers adopted into collective agreements. So if you recall, in the early days of COVID, many employers introduced things like hero pay or pandemic pay in order to thank employees for continuing to work during uncertain times and to, quite frankly, to encourage people to come to work. In a case involving Rexall and the UFCW, Rexall introduced a pandemic pay of an additional $2 an hour for every hour worked. It was introduced early on in COVID, and ultimately it was eliminated in late summer of 2020, kind of when restaurants and the province started to open up. At this point, the union filed a grievance, and they argued a number of things. First, they argued that the $2 premium was in fact negotiated into the collective agreement and that the company couldn't unilaterally end the practice. Two, they also argued that the $2 premium was in light of essentially the creation of a new job classification that was created because employees were required to do extra functions like wipe down workstations, help customers navigate through stores by ensuring that they were still socially distanced. In my view, it was a bit of a stretch to make those arguments, but I understand politically why a union had to at least take that position. It went to arbitration, and the company ultimately argued that the grievance should be dismissed on a prima facie basis. And what that means is, even if you take the grievance, all of the allegations that have been pled, and assume they're true and provable, the employer took the position that a collective agreement still hasn't been violated as a result of its practice to implement and ultimately end pandemic pay. The arbitrator, in large part, agreed with the company and dismissed 70% of the allegations without having to hear any witnesses or any evidence. And I think in large part because in that case, the company did a good job in their communications of when they introduced the pandemic pay. They introduced it in writing to the union first and then to ultimately the employees. It was, very clearly stated it was temporary in nature. It could end at any point in time. Notice would be provided. And ultimately, the arbitrator determined that just based on the pleadings themselves, that there couldn't be a violation of a collective agreement based on the implementation and the ending of this practice. So once the arbitrator dismissed 70% of the allegations, the grievance ultimately went away and the parties moved on. So just something to be cognizant of. I put this in the category of no good deed goes unpunished. You had employers do, a lot of good things, bending over backwards to make sure everyone worked in a safe environment, especially employers that were in large part required to stay open because of their essential nature of their operations. And ultimately, a union did file grievances, and there were many employers who faced similar grievances. But I think the end result was very similar to the one in this case.
And I'm sure that was due in no part to the fact that you were counsel on this case as well. But with that, Mike, we've been talking a lot about the economic factors and how they've influenced bargaining, but let's talk a little bit about unionization. So when it comes to the non-unionized sector, how is the current economic factors impacting on organizing generally?
I think if we go to the chart, you'll see on this chart maybe some things that are actually surprising. You'll see the light blue is meant to be the public sector and the darker is meant to be the private sector. To give you a sense of the comparison on this chart, what it says really is that the public sector had a density of unionization back in 1997 of 70%, and it's cycling up. Today, or in 2021, the most recent statistics would say that it's now at 74%. That 4% 4%, believe it or not, is fairly significant in terms of the density. And so, Catherine, we think that means the higher the density, sometimes the more leverage, frankly, in that sector that you're bargaining, and also some more leverage with respect to trying to unionize other employees that are outside of a trade union in that sector. Private sector is interesting. It was back in 1997, again, it was at 19%, but in the private sector, we're actually seeing it decline. So union density in 2021 in the private sector specifically was 14%. And so in aggregate, the overall density across our country is around 30.9%. Things to think about, many of us have US parents with Canadian subs. Many of us have relationships with US companies. Employees do, subject to immigration, they flow back and forth. The private sector in the US, its density is actually now under 6%. So a fairly significant decline. Whereas if we were back in 1965, we would say our respective countries were pretty close on union density. The other thing that's happening in the US, and I say that because sometimes these trends float north, the US would now say under President Biden that unions now have a popularity rating of 70%, something unseen since the 1960s. And there is a bit of a worry that that's floating north and going to put more pressure on union organizing for employers. And the message might be landing a little bit better than it has over the last decade. Overall, what that means is I think if we start to look at the various reasons unions are being successful in organizing, we'll see that they're putting an emphasis on social causes. So it's not simply sign a card so we can negotiate with your employer. It's more sign a card so you can help us affect a social cause. So whether that be something like sick pay and care for people, forgetting whether it's a collective agreement or not under COVID. Some of us will remember the Fight for 15, where there was a desire to try to increase the floor of minimum wage across the country, both in the US and in Canada. Child labor, it's not that long ago that we saw unions say, join us and fight employers who aren't taking care of their supply chain. So if in their supply chain there's child labor or there are horrible working conditions, remove from that employer, but still within the supply chain, help us cause them to have an impact on that supply chain. And so the health and safety piece really plays into COVID. They've emphasized and they've tried to hook that. I think Sandeep's right. If you look across the various industries, employers have done a very, very good job with respect to upping their game in health and safety. Construction was one example that was able to stay open almost throughout COVID. And that was really a testament to employers and employees and trade unions working together to keep those sites safe. Increased cost of living, if you're only getting 1 or 2% from your employer, join a union and we'll negotiate higher rates. And then finally, the message really hasn't changed. Job security is one that we tend to hear often from folks. I think I'd leave you. I'm going to ask Sandeep to jump in and talk about our various legislative structures around the country as it relates to how a company could become unionized. I'd leave you simply with one thing that is seemingly changing, but I think it's been pretty consistent the last decade. We used to have leaders in a command and control structure. I think command and control is passé, and I think what we're really looking for, and I talk about leaders because I think they're one of the significant reasons when people make a choice as to whether they're going to join a union or not. Most people today are looking for leaders who they trust and who can be inspiring, not who can dictate and command and control, but those who are actually looking at finding a way to be trusted by their workers and to inspire their workers. And ultimately, at the end of the day, have really a good set of ears. They're good listeners and they try to solve issues. But with that, I'll jump over to Sandeep, I think, to comment on these legislative structures that have an impact as well.
Well, thanks, Mike. The environment we operate has changed. And just one example of that is labor boards right across the country are now accepting electronic signatures on union cards. Now, this is different. And in my view, it absolutely helps unions organize because more and more campaigns are taking place without any face-to-face meetings. Everything from card signing, right, to meetings taking place, to campaigns taking place on Facebook Messenger and WhatsApp groups. A lot of it is becoming a lot more underground in terms of the organizing efforts. And I think that impacts employers more so in provinces where there's a card-based certification model in place. Provinces like Quebec, New Brunswick, PEI, and now British Columbia. This is a concern because, historically, take a province like BC, we always had an opportunity for a vote. There was an opportunity to be notified that at least 40% of your associates or employees had signed cards. That's now gone in a province like British Columbia. And now when you add on the ability to get electronic signatures, I think a lot of employers were quick to find out about organizing efforts because meetings were taking place at a hotel or a local Tim Hortons or a Legion, whatever it may be. And that's just gone. Like, the organizing has fundamentally changed to a tech-based model where it's becoming more and more difficult for employers to be notified and advised and become aware that organizing is actually taking place. So gone are the days where, employees are handing out little, 3x3 cards to get signatures, because it's all taking place virtually. So just be cognizant of the environment in which we're operating and whether or not you're operating part or all of your business in a province that has a card-based certification model.
Well, and to that point, Sandeep, in this environment, what can and should an employer do if it wants to remain union free?
As a firm, we're telling clients right across the country that we're in a unique environment right now. So on one hand, employees are absolutely feeling the financial squeeze at home. And in my view, people are just generally disgruntled. As such, in my view, like, there's no better time than right now to do some town halls, to do some listening sessions, just to listen to your employees and figure out what is, and more importantly, what is not working. I think we could learn a lot from our employees right now. And there's significant value in providing our employees with a platform to share their concerns, should they exist. So I think right now we're in this unique time right now, and I think our human capital is really our number one asset right across the board. And I think from that perspective, we need to spend time. We need to understand what is actually working, because even asking open-ended questions like, how do you think we did during COVID? I don't think any employer got it right, perfectly across the board. I think a lot of employers tried their absolute best to try and figure this out. And now, as we deal with, bringing people back into the workplace, I think it's important to really truly find out. And from my experience with employers who have done these town halls or listening sessions over the last couple of months, it's been incredibly valuable in terms of employees just sharing their information or sharing their concerns or sharing what is working. And I think both pieces of information are extremely valid. And, I think you will be quick to know whether or not, you've got a level of dissatisfaction that could ultimately lead to union organizing, or ultimately, if you're in a good place right now, you just need to build on everything that you've done over the last, 10 to 12 months. So take that time right now to really, truly address some of those issues and spend more and more time with your employees, especially as you get more opportunities for face time.
So thanks for those comments, Mike and Sandeep. We're going to change gears now and move a little bit into talking about the wage restraint legislation and case law. So I want to turn to you, Mike, first for a brief overview of what this type of legislation looks like and where are we seeing it from a cross Canada perspective.
Great, thank you, Catherine. So let me start in Ontario and just make sure we're clear with some of this. In Ontario, we're going to spend time talking about what people refer to as Bill 124, or what the provincial government called it, the act that is protecting a sustainable public sector for future generations act. It was brought into law back in 2019. That's where we're going to spend our time as we refer to the wage restraint legislation, not really on what everybody read over the course of the last 10 to 15 days with respect to the Ontario government's bargaining with QB in the school sector. That's a different area. We heard lots about the notwithstanding clause. We're really going to focus on wage restraint legislation, not only here in Ontario, but across the country, because it has had a significant impact on collective bargaining tables where it applies. So if we start with Bill 124 in Ontario, the purpose of that act was to ensure that increases in public sector compensation reflected the fiscal situation in the province. Remember that the provincial government said they came into power and they were faced by significant deficits. And so they put this Bill 124 in place, and it said the act would establish 3 years of moderation, and the moderations were for both unionized and non-unionized employees. And they said during the applicable moderation period, salary increases are limited to 1% for each 12-month period of the moderation period. And so that had a significant impact. That cap actually held, and we're going to talk a little bit about how that affected interest arbitrations and collective bargaining. But in Ontario, cap of 1% on compensation increases over that 3-year period. Some employers are now moving outside that period because they started in 2019 or 20. So we're actually starting to see the end of moderation for some employers as well. In Alberta, there was a wage freeze on all non-unionized public sector employees. That ended in 2021, the end of the year, December. In Manitoba, there was a 2-year wage freeze, and then they actually stipulated what the increases would be in the back 2 years, and you'll see it says 0.75% in year 3 and a 1% cap in year 4. But take a look at that little cautious note. That's what they intended to do, never got proclaimed into law, and it was actually repealed this past summer. Nova Scotia, same thing, a 2-year wage freeze, again, stipulating what the caps would be in the back end of the collective agreement, 1% in year 3 and 1.5% cap in year 4. And then notice the Nova Scotia one, the tweak, a 0.5% cap on the last day. Some of us would say front end loading the next round of bargaining. But we've seen that really is called back end loading, but it depends on the eye of the beholder, I think, sometimes. With that frame across the country, we've had court challenges to this wage restraint legislation. And obviously we've had one here recently that's been successful at that first level of challenging Bill 124. We'll talk about that as we go. But I think with that, I want to move it back to Sandeep, who will dive into more of the detail in terms of, frankly, what the courts think of these wage restraint legislative efforts by various provincial governments.
Thanks, Mike. Yeah, if you're looking for consistency from our courts across the country on these issues, we won't find it yet, I say, and I use the operative words yet because I'll bring into play this current situation in Ontario. Like as Mike mentioned, 3 provinces enacted very similar legislation, all with the intent to create fiscally sustainable public sectors by putting legislative caps on wage increases for certain public sector employees. So starting in Manitoba first, because that was the first one to go through the court cycle, the government enacted legislation. It was time stamped at 4 years, and it was aggressive in terms of actually having wage freezes for the first 2 years. Almost immediately after the legislation came into place, trade unions in Manitoba filed court proceedings claiming that the legislation was unconstitutional. Specifically, the unions really argued that, from a freedom of association perspective, which includes the right to collectively bargain and negotiate, they couldn't because of this legislation. When, their arguments at the trial level were simply that wages are so fundamental to collective bargaining. And if you're telling us that we can't even negotiate those increases in years 1 and 2 from a wage perspective, we're basically stripped of our rights, as it relates to the constitutional protection. At the trial level, the court agreed with the unions and found that the legislation was unconstitutional. However, on appeal, the Manitoba Court of Appeal reversed this decision and ultimately held that the legislation was in fact constitutional. As the legislation, specifically, they relied on 2 main important facts. One, that there was a timestamp on this legislation. One, that it was only for a 4-year period of time and it wasn't in perpetuity. In 2, they said they didn't buy the fact that wages were the only issue or the most important issue. They said the Court of Appeal ultimately said there's other significant issues which can still be negotiated through the collective bargaining process, and therefore the rights weren't actually infringed. Now, I think the important part here is after the Court of Appeal decision, the unions in Manitoba tried to appeal the decision to the Supreme Court of Canada. And the Supreme Court of Canada recently denied the leave to appeal, which I think says a lot. So the Supreme Court of Canada says, no, we're not going to hear it. The law of the land is what the Court of Appeal in Manitoba said. This legislation, which puts restraints around wages, is not, in fact, unconstitutional, and therefore it stands. Now, when I talked about consistency or lack thereof, I'd now turn to Ontario. Now, in 2019, as Mike mentioned, Bill 124 came into law. Almost immediately after it came into law, a number of trade unions stated their intention to challenge the constitutionality of this law. Now, that challenge went before the Ontario Superior Court in September of this year, so recent. The key issue before the court was whether Bill 124 infringed on the right to freedom of association. So in essence, similar to Manitoba, the unions argued that the caps on wages strip unions of their ability to negotiate rates that could be higher. And I think this is where the union actually did a good job in arguing. They said that it also, the restraint on wages actually prevented the unions from trading off salary demands for non-monetary benefits, things like, that became pretty public, which are, staffing issues and whatnot. And the Superior Court, similar to the trial level in Manitoba, agreed with the unions and determined that the legislation was in fact unconstitutional. Now, specifically, the court held that the purpose of collective bargaining is to ultimately equalize power imbalances. And the fact that such a key component in the collective bargaining process was capped, it effectively stripped the unions of their ability to collectively bargain. Now, I will note that as soon as the decision came out, the Ontario government has already expressed their intention to appeal this decision. So we'll have to see what ultimately happens in terms of next steps. But that's where you have this level of inconsistency right now, where Court of Appeal in Manitoba says, legislation is constitutional, and in Ontario at our Superior Court level, they've now ultimately said similar legislation is unconstitutional. So time will tell to see if our Court of Appeal ultimately hears this and what they decide.
Thanks, Sandeep, for that overview. And so when we think about the impact of Bill 124 over the last few years, Mike, can you talk to us a little bit about how it's impacted interest arbitration specifically?
Sure. Thank you, Catherine. I think what we're seeing is, and where we see evidence of this is at the interest arbitration table. So a collective agreement round of negotiations has not resulted in a deal. The parties have moved forward to arbitration, and arbitrators are now faced with typically a group of employees who are covered by Bill 124. And I would say fairly consistently, absent what Sandeep has just talked about, right? This new court outcome only a week ago. Up until that point, I think most of the interest arbitrators have said, we will adhere to that 1% cap if this employer who's in front of us is in fact in the moderation period. And so the arbitrators, though, have also had a little hook, and that hook has said, in the event that an employer has been found to be exempt from Bill 124, or in the event that Bill 124 is found to be unconstitutional, we retain jurisdiction, or we direct the parties to meet with each other within 60 days to address the impact of that kind of an outcome. And so that hook still applies. So first answer, arbitrators are respecting Bill 124, but they are putting hooks in. And now those hooks, many employers are probably facing the impact of those hooks in what is a very interesting period of time, because you've got a court striking down a piece of legislation. But as you heard Sandeep saying, a government likely to appeal it. What do we do in this gap? And many of us are saying, in the gap, you continue to talk to your bargaining partners all the time, but we think you should be reticent to make any quick moves, because if, for example, the decision is stayed, Bill 124 may still apply in that period of time. And if Sandeep was doing crystal balling and the Ontario Court of Appeal actually overturned the lower court, we could be back in a situation where Bill 124 actually applies. And I think increases in that gap could be problematic. So we would say to people, go slowly, speak to your trade union partners, obviously, but go slowly. So I'm a little beyond this slide, but that's what we would leave you with. If we move over to the next one, we're trying to take you through some of these arbitrations to actually try to breathe life into that first slide. This decision, participating nursing homes, is seen to be a master agreement. It's a leading indicator in this area. At least many people would think that, and certainly this arbitrator Stout thought that when he was looking at this specific group of employers, because some were covered by Bill 124 and some were not. And so he had to make the distinction, and he was very clear. He said Bill 124 applies to every licensee under the Long-Term Care Homes Act, other than a licensee that carries on its activities for the purposes of gain or profit to its members or shareholders. Accordingly, Bill 124 does not apply to those participating homes in that group that operate for a profit. And so he actually showed the distinction, and you could hear empathy in his voice. He said, but for 124, I would be awarding a greater increase. And you'll see that increase, the split was 1% adhering or respecting the cap in the moderation period, and then 3% for those who were outside of Bill 124's application. So that's a leading award, we think, in terms of how this was dealt with. If we move from there, the next one, again, unions argue that Bill 124 shouldn't apply in the participating hospitals agreement. And again, there's that little hook. And remember that ultimately, in this decision, the hook still sits there, so that hook may become effective. But remember, they said, we, the Interest Arbitration Board, shall remain seized in the event that Bill 124 is declared unconstitutional. If we move from there, we get into the College Employer Council case. And again, Sandeep mentioned this earlier, there's another wage reopener in that language of that interest arbitration as well. And in this one, the arbitrator ordered that if Bill 124 is found to be unconstitutional, I order the parties to get back to the table to negotiate what should be the remedial outcome in that situation. If we move from there, I think the next one we go to is trying to figure out, what are we going to do if somebody has a moderation period that actually only applies for part of their future collective agreement? And some of us would worry or think, well, the natural thing will be, well, there should be a catch-up. And so if I've been living with 1% increases all along, I can expect I'm going to negotiate with my trade union colleagues something that is in the form of a catch-up. But as we would say, please beware, because in section 124 of Bill 124, it actually prohibits what we would call catch-up. So they would say an employer shall not provide compensation before or after the applicable moderation period. And so you have to be very careful as you move into that post-moderation year in terms of what you're actually going to do with respect to wage increases. And if you used, for example, something like in year 3, the first year outside the moderation period, we're going to do a catch-up of 3.5%. I think you will attract attention from the Ontario government, certainly with respect to Bill 124 and Section 24, all on the assumption that Bill 124 survives as it works its way through the court system. If we move from there, the next thing that we would talk about is a case that really says this. Instead of using words like catch-up, arbitrator Goodfellow in this long-term care case actually said, I've got a 2-year period, first year still in the moderation period, I respect that 1%. However, and this is how the words he used, and we think this will stand the test of time, even if Bill 124 applies. He says, inflation has jumped so significantly, the purchasing power of the dollar that the employee is earning is being eroded so much, I award a greater than normal increase because of inflation. So he hooks it to inflation as opposed to the word catch-up. And we think that's really critical in terms of if you're bargaining and you're trying to preserve the deal, because sometimes employers are actually looking at these deals to say 1% has made it very hard for me from a talent retention perspective, I actually need to make this move, and I want the move to be solid and not challengeable. So in this situation, I think you're safe. And I still operate from the perspective of giving advice that 124 may become law. In other words, it may be the lower court might get overturned. So we're still thinking in terms of 124 and still trying to find deals at the table. And that's not going to be easy in this period of time. But I'd simply leave you with, watch out for words catch up. Think of inflation if you're actually looking at an increase more than the moderation period.
And Sandeep, on that, are there any other things that people should consider if they're going into, if you are a Bill 124 employer is going into bargaining? I think Mike's touched on that as, you know, about the proceed with caution, but any other final thoughts on that?
I think Mike was bang on by just taking it slow. So we still haven't, I think the one thing to expect though is as we come out of moderation, unions are going to come roaring at the collective bargaining table. And I think their focus is just going to simply be on current economic conditions. Inflation is 6.9. Let's talk money and let's talk lots of money. And I think for the non-union employers in the industry, like unions are going to come roaring and from an organizing perspective. So I think everyone has to kind of be, recognize the environment we're in right now and just kind of be ready for that, whether you're at the bargaining table or you're wanting to continue to operate union free.
I want to spend, I know we're at 10, but I want to spend a few minutes still with talking a little bit about practical tips for the bargaining table. So Mike, can you talk to us, certainly we understood that during COVID, things started to move virtually. Are we still seeing virtual bargaining or, are parties wanting to head back to that literal bargaining table?
So it's a great question. And I don't think there's a one size fits all outcome. I think many people want to get back face to face. And frankly, some people are still fearful of COVID and want to continue on virtual, on Zoom and on Teams. I think there's merits to both. If you have teams that have to travel, just that transit section is difficult for some people. So whether you're getting back to, if I have our druthers, I want to be face to face if we can do it safely. And that's a big if in terms of how this is cycling these days, in terms of COVID and other issues in our healthcare system right now. I would say the one thing that is a common feature, though, that I would recommend to everybody. Remember, we said get all this information, be on top and prep well for it. Well, also get all the information you can about the other team. I want the other team, and I want to make sure that they get to know me and our bargaining team, and I want our bargaining team to get to know them. Now, some people say, well, wait a minute, we work in the same environment all the time. There's still lots to get to know, because at the end of the day, when you're trying to cut a deal in the negotiation table, it's easier to cut a deal with people who you know and trust. So that means if I want to tell people I'm married and I have twin daughters and I'm into sport and I do this, I want to know that from everybody else. And I want to be able to, when I go back to that second round of bargaining and that third round of bargaining, I want to ask Joe how so-and-so did in that sport, or how Joe's son or daughter did at that piano recital. Get to know people. It sounds soft, but it actually pays off in spades when it comes to bargaining. So face-to-face if you can, respecting the health and safety issues.
Thanks, Mike. I think the other kind of tip for the bargaining table that we wanted to cover a bit with Sandeep was that it seems like there's a bit of a trend where union recommendations on a collective agreement, a deal negotiated doesn't mean a deal done, and that at times the ratification vote will fail. Is that your experience, and what are some strategies that can be used to increase the chances of a successful ratification vote?
Yeah, thanks, Catherine. These stats are not captured by the Ministry of Labor, but I can tell you there's a growing trend of tentative agreements that are not getting ratified. And these are agreements that are, bargaining committees are fully recommending to employees, yet employees in a ratification vote are turning them down. On a personal level, I'm having union reps tell me candidly that they're having to work incredibly hard to sell agreements now, and that the expectations from employees are just too high. What they're telling me is that, employees see inflation at 6.9, And that's the floor to negotiate, because they're saying that the dollar value only gets, the increase is based on that. And union reps who are savvy and have been doing this for a while understand that that's just not, it's not realistic. So from a practical perspective, here are a few things just to consider. Historically, after a tentative agreement has been signed off on, employers remain silent as it relates to sharing details and information on the agreement prior to ratification vote, as the union has taken control of that process. Legally speaking, there's nothing wrong with an employer engaging directly with employees in order to simply share details of the tentative agreement and the reasons why it's fair and reasonable. We're starting to see more of this. In my view, I think employers can effectively engage and communicate with their employee bases, perhaps more effectively than a union rep can. And that's no slight at union reps. What it means is that they've got multiple ratification votes in a week when, this is our baby. And so ultimately we have those personal relationships. There's pros and cons to this. And I'll say it only works if we have credibility with our employee base. Otherwise, it can come across as a bit coercive if we're trying to, be seen as forcing, an agreement, as opposed to really just educating our employees as to why we actually think it's a fair resolution. The other thing to remember is think big picture. If your collective agreement doesn't ratify and you miraculously come up with more money the next day in order to, entice employees to ratify an agreement, what do you think is going to happen the next round of bargaining? No agreement will ever get ratified on a first go around, because employees, will remember that, vote this down and there'll be something more on the table. As such, own the communication. And if you need to adjust proposals, if it has failed ratification, try and ensure that you're moving money around as opposed to simply adding. I know it's not always possible, but just think of the impact, for the next round of bargaining as you try and get a resolution on what's in front of you right now. And third, have a strike contingency plan in place. You just never know right now. Things are volatile. Things can happen real quickly. And if you're planning on operating during a work stoppage and you need replacement workers, good luck. Secure them early if you can. Historically, we've not had problems securing replacement workers and training them and getting them, ready and set to work in the case of a work stoppage. I think right now, just with the labor crunch, it's becoming increasingly tough to do that. So plan in advance, make those arrangements, reach out. If you're in that situation, we can help support you when it comes to that. And lastly, there's something called the final offer vote in Ontario. And what that means is in each round of bargaining, an employer just one time can take what it has proposed to the union, file it with the Ministry of Labor, and the Ontario Labor Relations Board will conduct a vote that will allow employees to vote on what our last offer was to a trade union. And this can be very helpful, but at the end of the day, it's a timing piece. I think we've seen that final offer votes can be successful if they're timed right. You don't want to have it too early in the process. Unfortunately, you probably got to go through a bit of pain if it's the fear of a strike or an actual work stoppage, but it is a tool that employers, I think, don't use enough in Ontario, and it allows an employer to really own the communication to say, we think this is fair and reasonable. The union, for whatever reason, didn't want to take it to a vote. We want you to vote on it. You can have your voice heard by actually participating in this vote. It's a secret ballot vote, and it's based on a majority of those who actually cast a ballot. So again, from a credibility perspective, if you have that and you're confident that what you have put forward is fair and reasonable, you do have that opportunity one time in every round of collective bargaining to ultimately do that. The only caveat to that is if you operate in an environment where a union can't strike, you don't have this option. But for the vast majority of workplaces in Ontario, it's there, and you have that as a tool to consider if you're in a tough round of bargaining.
Thanks, Sandeep. So just kind of on that point, if we're in a situation where you're an employer who's eager to get a deal, I think sometimes we're happy to agree to things at the 11th hour just to go home. But what type of provisions should employers be wary of agreeing to if they're at the table? Mike, thoughts on that?
I think what we've learned over, let's say, the last couple of decades, let alone these last 2 years, is that the one thing that is a constant is actually change. And so trying to predict what will be needed or not, what will be not required in future years is really, really challenging. And I think we would leave you, the listeners, with beware restricting your future flexibility. A simple one. It might be easy to say, we agree we won't contract out any of the work that these classifications do. That's a dangerous place to go, we suggest, because who knows in the future how you're actually going to provide that kind of work. Sandeep talked about a Me Too clause, and there are vagaries and dangers with that. Sometimes you can't predict what's going to happen 3 years or 4 years from now if you happen to be in a long agreement. And then I'd say finally, a really easy example. You have one unionized site, you're a national retailer, you have spots all across the country, you've got warehousing, the whole bit, and you negotiate an agreement that says benefits and pension plans, or our benefit and our matching RSP shall stay the same, period. You use language that clear. And then all of a sudden we have a downturn in the economy. You need to renegotiate across the country your national your national benefit program, but yet you'll have language that won't allow you to do it in a single site. And that does create issues. So we would simply say, think of flexibility. It's easy to agree to something that you don't think will have an impact in the next year, but we worry about the longer term impact where we may not be able to see that far out. I think I'd end there, Catherine, in terms of comments on this one.
Okay, thank you. I want to go to some of the questions from our audience. So Sandeep, I want to talk to you first. You talked about alternatives to wage increases, and one of the bullets on the slide was about Me Too clauses, but I don't know that we actually talked a whole lot about them. So can you just explain what that looks like?
For sure. If you're operating in an industry where you have a certain number of competitors, you may ultimately agree to something called a Me Too clause, which is if something is negotiated, or unions may ultimately try and get language in that if they're able to effectively get language in a different collective agreement, but it's with a comparator, it's within your industry, it's related to your business, that it automatically will be imported into your collective agreement, for good or for bad. I generally try and stay away from those clauses, just because, as Mike talked about, part of a collective agreement as we're operating a business is to get certainty over a period of time, whether it's a 2-year collective agreement, 3-year or 5-year. And I think those Me Too clauses take that out of your control. They could work for you or they could not work for you. But I think as we try and get certainty, it is something you can at least think about, but ultimately just be weary of them because it could impact your business fundamentally without you actually having control over that process.
In terms of the negotiation process and the bargaining process generally, one of the questions that's come up is about, when we're talking about ratification, are there advantages or disadvantages, or does an employer have any control over whether it's on site during working hours versus off shift versus electronic? Like, what role does the employer play in that?
I can jump in on that. Really none, right? It's a process that is owned by the union, and they're pretty hands-on about that process, and they like to take control of it. Now, if you've got a good relationship with your union partner, you can make space available for them in your workplace. But oftentimes unions like to control that process. They'll get hotel space, they'll do something else. Some unions have moved to electronic or ratification meetings, although I think there's a trend to do them more in person on the union side of things. So it really is owned. We don't control the timing of it. We don't see the ballots. We don't see any of that as an employer. It truly is run by a union and their own constitution.
There's a question here about pros and cons of entering into multi-employer, like let's say regional, industry specific collective agreements versus negotiating as a single employer. Thoughts on that?
There are pros and cons, as you would expect the answer to be. The pro would be you might stop the whipsawing. In other words, if think of the automotive sector, where they go after, as what we still usually call them, the big three. the union would typically pick one of those big three that they think they might have better leverage with, and try to strike a deal that they will thereafter call a pattern and try to force other of the big three to agree to. So in a multi-employer set, at least we stop the whipsawing. They go to company A because they think they're weakest and they can drive a high economic deal at 5%. They take that deal and they go to company B and they try to get the same deal. If you enter into a multi-employer kind of bargaining set, that stops that. Where we see it most often is in the construction sector. And there's actually a section in the Labor Relations Act that allows a group of employers to get together with a single union and become accredited so that there's only one agreement and nobody can vary from that agreement. So depending upon your sector, I think it's a great idea. Some people would say, depending upon your voice within that multi-employer group in terms of what you can or can't influence. But if you're trying to get a level playing field and you've got high density, it's not a bad idea.
And Mike, I'm going to leave our final question of the morning with you as well, because it kind of speaks to the moderation period in Bill 124, which you were talking about earlier. Do you have any thoughts on how you see employers managing the bargaining process, where the term being sought is one where part of it falls within a moderation period, part of it falls outside of the moderation period?
I think it starts by sharing a tremendous amount of data. And I don't mean share your books, but I mean, it is pretty easy to have both parties try to seek the same bargaining information. So we know we can go to the Ministry of Labor, Immigration, Training, Skills and Development, and specifically their collective agreement settlement library, and we can at least share data. So my first piece would be, can we get everybody on the same page in terms of what the applicable data is? And then devil's in the details, because that moderation period, we would say as an employer, it's clear, it applies, therefore it's a 1% cap. Moving into that next period, we know we can't do catch up, but we know there's an inflationary issue. We know we may have a recruitment and a retention issue. And it's so, I think sometimes it's agree on the base data, almost like making evidence-based decisions. See if you can get your trade union partner to agree on some of the factual pieces, and then you bargain from there. If we're talking about what do you do today, because you're going to bargaining tomorrow and Bill 124 has been struck down by a lower court, we still have discussions. But I think we go, as I think we said earlier, go slowly and pay attention to what's going on with the Ontario government and the specific unions as it relates to whether 124, whether there'll be a judicial review, and whether in the interim period that they will seek a stay. And a stay isn't a given. A stay is before a court, and they argue that the lower court decision should be stayed pending the review. So I'd say go slow if you're talking about going to a table tomorrow.
So I lied. I'm actually going to put one more question to each of you. Sorry. So practical thoughts, Sandeep, on if you're getting pressure, you've negotiated a deal, but you're getting pressure now because of the current economic circumstances to open it up and negotiate a raise mid-cycle. Thoughts on how to approach that?
Yeah, it's funny. I'm getting that more from our clients as opposed to unions who are saying, hey, we got a great agreement, you know, in 2021 in the kind of heart of COVID. Things have changed. Like, what can we do? And I think there's a couple different strategies. One is you can just simply go to the union and say, look, we need to reopen this process because what we have in the collective agreement right now isn't working for us. And, you know, unions are generally not disinclined to participate in that process if it's for the betterment of their members. The other thing that creatively what some employers are doing is if you have a grid that has a probationary rate, a start rate, a year one, a year two rate, some employers are getting an agreement from unions to say, hey, we're not going to bring people in at the probationary rate, but we're going to bring them in actually at not even at the start rate, but at the 1 year rate. And employers are doing that strategically from a recruitment perspective because they're noticing that their probationary rates and their start rates are actually too low. So there's a couple different ways you can, you know, attack that from a wage perspective. But ultimately, you know, reaching out to your union partner and saying, hey, we need to reopen this is generally not a bad thing. And it can happen. they'll remind you the next round of bargaining when you take a harder position on wages to say, remember what you did last time. But at the end of the day, we got to do what we got to do to continue to operate.
And then I'll put this out to either of you from a ratification vote perspective. During COVID, and now in the current times, how quickly are we seeing those types of votes being conducted? Is it a longer period than we saw earlier, or has there been a change?
I'll make a quick comment, then over to Sandeep as well. I'm not sure there's been any significant change because many unions have a practice where they finish and they get to a memorandum of agreement, and there's a specific length of time. Their constitutions require them to provide their membership with notice of the pending ratification. So that's the one piece that you watch for that I would say no change. But what we have seen is, believe it or not, electronic voting, if they're using that, actually we're getting a higher voter turnout. Just like you're getting on an application for certification, we're seeing much higher voter turnout. And while many folks have worried about, well, is somebody voting instead of Mike, the technology they're using has been very, very good. And we've seen very few cases, if any, that I can think of, frankly, where there's been any kind of voter fraud. So the electronic, I think, ups the turnout, which is a good thing for us, I think.
Yeah, the only thing I'll add to it is when we do memorandums of agreement, I actually put in a time frame for when a ratification vote has to happen by. It just holds the union accountable. I think as an employer, we want certainty. We've come to this memorandum of agreement. So consider putting that in your actual memorandum of agreement that a union will hold a ratification vote within 7 days or 5 days, whatever it may be, from an operational perspective. So I think it just creates that certainty and accountability.
I'm going to turn it over to Mike, but before I do, I just want to remind everybody that the slides and a recording of today's presentation will be up on our website in the next few days. So over to you, Mike.
Thank you, Catherine. Thank you, Sandeep. First of all, thank you very, very much for joining us this morning. We hope you found this session informative. This brings us to an end. If by chance we didn't get to address your question, please drop us a line. We will pay attention and look to get back to you quite quickly. Our next HR review webinar will take place on Wednesday, March the 8th. So that's Wednesday, March the 8th, 2023. Believe it or not, 2023 already. The topic is still in the design phase, but there will be invitations out in due course. If you're on our mailing list, you know that you'll receive that invitation. If you're not yet on our mailing list and wish to receive our briefing notes, newsletters, and invitations to seminars just like this one, please subscribe through our website. It's the big red bar at the bottom of every page. Finally, we'd also be very grateful if you'd fill out the feedback form that will pop up on your screen once you close the Zoom webinar this morning. Thank you again for joining us. If we can be of any assistance, Sandeep, Catherine, all of our colleagues here would love to help. Please don't be shy to give us a call. And with that, we hope you have a safe and happy holiday and enjoy a safe time. So thank you again for joining us. Bye for now.